Hi, everyone. Thanks for joining me. I always seem to do these last minute, so I appreciate everyone showing up. Let me see who we got here. Julie's here. Kelly's here. Jen, Tanya. Thanks, you guys. Appreciate you being here. I don't know if anybody else is doing a live right now. I never know what anybody else is doing. So I just decided this was going to work for me. So that's what I'm doing. And I should probably take a drink before I start because my mouth's already dry. I hope everyone had a chance to at least look at the state's response. It's been going around Twitter for about an hour or two, maybe 2 hours at the most. And I just finally had a chance to upload it to the group. So I hope everyone's had a chance to look at it. It's not very long. I think it's 23 pages. And honestly, it's nothing I didn't expect. It's exactly what I expected. Oh, Millbilly already did his. Good. Okay. I don't like interfering when other people are doing lives, but sometimes it's just like I did a video earlier with Paul that we recorded for the live stream for this weekend. And so I was kind of already camera ready. So, well, I call this camera ready. Most people would not call this camera ready, but I do, meaning my hair is combed. That's all it takes for me to feel camera ready. So I don't like interfering with other people's stuff, but this was really just easy for me to get on right away and talk about this. Julie also has the document up on the Work with KZ website. So you can always go there. She does a great summary of everything and lets you know what's going to be happening next. And in this case, Kathleen will probably file a reply, she'll file a reply, most likely within the next day or two. She won't wait longer because she'll want to say something before the court actually responds to this. But here's the thing. When I read it, I almost laughed to myself because this is just another carbon copy of the previous time they tried to oppose the motion to stay and remand. And this is what took me. I was a little bit late because I was digging through some stuff. And in this one, they're essentially using the argument that this appeal has been dragged out long enough and that we've been languishing in this appeal for 4 years. And they were complaining about the constant motions to remand the case and adding all of these supplements or wanting to add all these supplements. And now basically enough is enough. They essentially just wind through the entire thing, which is what they do. And I expected that. I wasn't sure if they were going to argue it on procedural grounds, but if you did watch my last live, you'll know that my biggest concern was that there wasn't any corroborating evidence included. So it really was no surprise to me that the only argument on the merits that they had was that there's no corroboration here. And they elaborated on it a little bit more than I thought they would, but I guess they have to have a reason for bringing that up because I believe last time that the Court of Appeals said that they didn't really give them anything on the merits of the case. They didn't explain anything about the merits or give any explanation on the merits. So they just complained about procedure. So they were like, well, so I think that this should go down to the lower court for fact finding. They're also saying, yes, and the discrepancy with the dates. I actually didn't mention that last time because I didn't actually really notice it until after I got off air. And then I saw it and then I realized, oh, that could be a problem too. Just because if you remember, Kathleen put on the motion that she was approached by this witness on April 11th, but Thomas Sawinski's affidavit was signed and dated April 10th. And that is a bit of a problem. It's not huge. She can always say she made a typo or something. It's not huge, but when the state is going to be struggling for an argument, you really don't want to give them hand anything to them. And that's one thing that she just basically handed them on a silver platter, that it's going to call into question the legitimacy of this since she doesn't even she's not even telling the truth about what date he came forward. That's what that's what they're trying to give that impression. They also were wrong in the facts. I mean, there weren't many facts to even remember in this motion, and they still managed to think that somewhere that Sawinski said they pushed the car uphill. which was never brought up. That is not anywhere in his affidavit. Nothing about them pushing the car uphill. So you sit there and you just have to wonder, where do they get this stuff? It's that's what makes them comical at sometimes, because you were literally arguing something or pointing out something that was never said. So what are they looking at? Where did they get this information from? And it's sloppy. It's very sloppy on their part to say something that was never mentioned. And you can believe that Kathleen's going to jump all over that. Now, as far as the lack of corroboration, that is where I see a problem. And I said that since last time. I said that I feel like she had to do something to prove that she tried to corroborate this alibi. And my question was, or my comment was, that we don't know that she didn't do that. We just know it wasn't presented. And she doesn't have to present everything. She can save the details for her brief if it gets remanded. But that's the key phrase, if it gets remanded. She has to give the Court of Appeals enough of a reason to approve this motion, to affirm this motion. And so that is where my original concern is, and that's where my concern still is. If Kathleen is denied this, it's going to be probably because she did not provide enough information. Now, like I said, Kathleen will file a reply, and she may cover some of that. Why she didn't include it to begin with, I don't know. Because I said again, last time I said, I find it very hard to believe that Kathleen Zellner would do this and cause this kind of delay unless she was sure that this was something big, that this was worth doing. What she presented in the motion doesn't tell us that it was worth doing. It really doesn't. But I don't believe that she would do that and not have any evidence to back it up, or not have done her homework. You know, that Kathleen covers her bases. Okay, this is not her first go around. You know, she knows what she's doing. So, you know, my only question is why she didn't include more, but I don't believe that she doesn't have more. I believe she has something more. She has to. So whether she's going to explain all that in the reply, maybe she planned on that. Maybe she's like, well, I'm going to see what I can do with just this, and then I'm going to add more in the reply. But technically, the reply is supposed to only be in response to the state's rebuttal. She really is not supposed to throw in anything new. But if we've learned anything, Kathleen doesn't really play by the rules. When the state does say things about her not following procedures, okay, I can't argue with them on that point, because she really doesn't. She kind of just does her own thing. And this is what I wanted to point out. That's why I was a little bit late. I was looking for something. I'm going to read something to you here. Staying this appeal and remanding for the litigation of such a motion would result in unnecessary delay and litigation. This appeal has been languishing for over a year. If Avery no longer wishes to challenge the denial of his previous motions, but instead litigate an entirely new 97406 motion, he can voluntarily dismiss this appeal and pursue that action in the circuit court. It is inappropriate, however, for Avery to continue to ignore Wisconsin rules of procedure. Okay, if there's one thing you probably noticed, I said languishing only a year. That's because that is word for word what they put in their response to the last motion to stay and remand. That is exactly what they said in this one. Okay, they said essentially the exact same thing. They didn't copy and paste it, you know, word for word, but it is essentially the same sentiment. That is exactly what they said 2 years ago, or a year and a half ago, whatever it was. And well, yeah, it'll be 2 years ago. Yeah, it was January of 2019. So 2 years ago. And that's their same argument this time. And what's interesting about that is that the Court of Appeals made it clear. I hate that they keep saying, well, if you want to just dismiss this one and file a new petition, then you should just do that. It's ridiculous for them to say something. And so this is what the Court of Appeals said last time they said this. The state suggests that the appeal is languishing, and that if Avery wishes to pursue new claims outside the scope of Wisconsin Statute 97406, post-conviction orders presently on appeal, he could dismiss the pending appeal or wait until its conclusion to file his new claims. As to the former, meaning the first part, Avery understandably disagrees, aware that dismissing this appeal will preclude review of the underlying orders entered to date. So the Court of Appeals flat out told them that was a ridiculous thing for them to say. And they did it again anyway. Now, the difference with this one is that the Court of Appeals went on to say in that one, having considered the parties' submissions, we determined that the best course of action is to grant Avery's motion to stay the appeal and to remand for action upon specific issues. I don't know if you guys remember, but that was the key point. That action was needed upon specific issues. The state again tried to say that they want to raise a new constitutional claim. And you can't just raise new issues. And the Court of Appeals is saying, yeah, you can. They're relying on what the Court of Appeals did with the motion to remand for the scientific testing, which is a totally different situation that had nothing to do with anything that was currently under review. This has to do with what's currently under review because of the fact that, again, there's the Brady issue, which is the center of this argument, because this is a Brady claim. Forget about all the details of what the implications are for the case, but this is a Brady claim. But the Brady claim is referencing the fact that had they had this information, they could have more properly impeached or discredited Bobby Dassey's testimony. That issue is very central to part one of her claims that is currently in front of the court. She's arguing about how they improperly argued the Denny motion, how his previous attorneys improperly argued the Denny motion, and because of that, they were not allowed to present Bobby as a third party actor in this case. And so for the state to say it has nothing to do with what's in front of them, it actually has very much to do with what's in front of them right now. Because they have to make a determination whether there was an IEC claim, because the lawyers did not investigate. They didn't find the computer. They didn't find information that was vital to impeaching the star witness of the trial. Henberry, hi. Let's see what you're saying here. Mr. Avery has remained in jail exactly where we want him to remain for 4 years now, while he continues to delay his own appeal and remain in jail exactly where we want him to remain. Yeah. That's absolutely true. That is what they want, and obviously they're not going to put it in those terms, but that is what their goal is. Their ultimate goal is to keep Stephen Avery in jail. So I don't think they have a leg to stand on with the whole, you can, dismiss this and start over, unless, well, they're never going to dismiss it. Again, I think the Court of Appeals is just going to blow that off. The other option is to let this appeal play out and then file a successive petition if they lose on this case. Now, of course, there is a problem with that, because you can always bring up procedural bar, which should not be an issue if this was just brought to her attention within the last week or so. This month for sure. I mean, if this was just brought to her attention recently, procedural bar should not matter. But there's always a risk of that being a problem. So I don't know if the Court of Appeals would ever give an assurance that it will not be, considered procedurally barred because we're too late in this appeal right now, and so therefore you'll have to file this in a successive petition. I don't know if they'd ever come out and say something like that, because they can't really say it without fully evaluating it. But I don't know how you can say, well, we're just going to ignore this because it's it came at an inconvenient time. I mean, that's not the proper way to handle it either. You can't say, well, this is just not a good time because we're already into this appeal, which is the state's biggest argument. We're past the briefing stage. This is already in your hands. And this is one of the things I raised in the last live, was that I was concerned because That's never been done before, as far as I know. Not in Wisconsin. I know that Travis and I looked at cases where there were remands, and we could only find a couple that ever had remands, let alone after briefs were submitted. So I don't know what the rule of procedure is on that. And I'm pretty sure the state doesn't either, because they're just as lost on some of the rules of procedure. So that's the one question that I can't say whether that's a good argument or bad argument, because I have no idea what the Court of Appeals is going to do with that. Because we are in a different stage. That part the state is right about. Pre-briefing, you can still add things, but now that we're post-briefs, it's really hard to say what the court is going to do with that. But I wouldn't be so confident as the state seems to be that they're automatically going to dismiss this, because there are other issues to consider. They cannot set her up or set Steve up to be procedurally barred when she tried to file it in a timely manner. Is there any way to get proof of the call to the sheriff's office? Well, that's the thing. Kathleen's certainly going to try. She's not going to ignore it. She may have already tried. We don't know. But the state makes it sound like, oh, it would be so easy. Just contact the state for the phone calls. We all know that it's not that simple. Okay, they can't be trusted. I say collectively, obviously I didn't do it, but the people, the supporters of this case have already requested the phone calls, and this was not included. That doesn't mean this doesn't exist, because when they requested certain calls over FOIA, they were only given a small amount of calls, but then when some other calls were in the same time period were requested, they got thousands of them. So there's really no way to say for sure how easy or difficult it would be to get this phone call. Obviously, if it was easy, well then, duh. It's not like she didn't do it. And that, again, is the state's argument also. They're arguing that Kathleen did not do any investigation. She did not do any due diligence in trying to corroborate this statement. And that's where I was saying, like, I'm not going to say that she hasn't. I'm not going to make that jump. But I can understand why they made the argument. Because from all appearances, it looks like there was no effort to corroborate anything. That she's just giving this guy's statement without vetting it at all. But she wouldn't do that. So, yeah. But as far as whether the state, they have it, I wouldn't bet on it. They're very good at losing things, if you hadn't noticed. Especially things that have a voice a voice message to them, or something that's recorded. They're very good at losing things that have been recorded. It's amazing. And I don't know what else specifically was in here. I know I wasn't going to keep this too long, because I mean, they really didn't make any really mind-blowing arguments. Again, they're doing this whole that Avery is permitted to petition this court for remand to the circuit court for action upon specific issues pursuant to the state statute. And they're saying that there aren't any. And that's not the way I look at it. They said they're ignoring the fact that why this Brady claim is important. They didn't argue anything against the actual Brady claim itself. They didn't go into what's required to substantiate a Brady claim. They went to other procedures. They argued against other procedures. They brought up State versus Henley. There's a case that I have quoted more. There is not a case I've quoted more than Henley, because they love relying on that. Just saying that that's not one of the rules of procedure when it comes to post-conviction relief. And that's because they're ignoring what the central issue is, which is this is a Brady violation. So there was nothing in there arguing, as far as I remember. Again, I read it only once, and that's it. So I probably missed things just like last time, or didn't read it carefully. But I didn't see anything about them arguing against why this wouldn't be a Brady claim. So again, they're not really arguing the merits. They're arguing the procedure. They're arguing that this is not timely and that they're too late in the process to do this. They're arguing that this is a stall tactic. They're arguing that Kathleen did not do enough investigation to warrant filing this motion, which in turn means that this is nothing but a delay tactic. That's what they're all arguing, but they're not arguing anything with regards to the actual Brady violation, which I don't know what they could argue because there's nothing, what can they say? They can't say this guy's a liar because I don't know. They haven't vetted him any more than they were saying Kathleen did. So they can't argue against this guy saying he's not for legit when they have no idea. So what will KZ's next move be? Well, she'll file a reply to this. Without a doubt, she'll file some kind of reply. But I don't think that she can include anything new. Well, okay. Procedurally, she cannot include anything new. She may say something like further corroboration will be available or be explained once it's back in the circuit court and I have the opportunity to fully brief this issue. She could say something like that. But no, yeah, why would she want to delay? She doesn't want to delay. And Steve does not want her to delay. Again, to think, I don't know what she would have to gain by delaying this farther. If anybody can think of anything, let me know, because I really honestly cannot see what she has to gain. Her client stays in prison the more this is delayed. As longer each time this gets delayed. So no, that's not what she wants. And they did make an argument. I almost forgot about this. They did make an argument that filing all these supplements ends up presenting as a total document. If you look at the brief with all the supplements, there does end up being some conflicting theories. And they point out how she at once was accusing Ryan Hilgis, like he was the only one that could have done this, but then all of a sudden she switched to Bobby Dassey. And I'm not going to lie, that is problematic because that is confusing to the Court of Appeals because they'll be like, wait a minute, right here you're saying that all this evidence against this one guy, and then you have all this evidence against this other guy, and her theories that she's presented along the way. And this is why you really need to be careful about what theories you decide to use because some of them now don't make sense based on what she's presenting this time. And that is something that is dangerous. And that's why you don't usually present an appeal piecemeal. But like I explained last time, this is a very unique situation. This is an investigation that's never going to be done until the real killer is found. So she has no choice. It's a fluid process. So she really has no choice but to file things as they come to her, because what else is she supposed to do? Let me see. Why do you think she filed so fast after talking to the witness before getting phone records? Well, I'm not convinced that she did. Again, that's where the date screw up comes in. Clearly, he didn't come forth on April 11th because he signed the affidavit April 10th. But when he actually came forward, I have no idea. But I don't believe that she wouldn't have gotten some type of corroboration or at least something that convinced her that this guy was legit and that his story would hold up. I was scratching my head and when I did the last live saying, why wasn't some of this included? Because I think the court needs to see that. But I don't know. But I don't believe that it was as fast a turnaround as it seems based on the dates. I just can't. I don't know when it happened. It just doesn't seem likely that it was just the next day or, that day that she also decided I'm going to file or 2 days later. I think Kathleen's way too smart for that. And that's just, a guess on my part, but it's just logic. It's common sense. Why do I think the court has not filed sanctions on KZ? Because she's playing, she's playing the game. When they say she's game playing, well, yeah, she kind of is because that's what lawyers do, but she's not playing a game in the sense that they're acting like she's delaying things for whatever reason. No, but she's got some gamesmanship. We've seen that from Kathleen before. She taunts them. She likes to basically call them out on the stupid stuff they say, and she does stuff like that. But she's not doing anything that is really anything worth sanctioning. There are lawyers that have done horrible things and they do not get sanctioned. I think Wendy told me once that she said, essentially, as long as they're paying their dues, they're not going to get sanctioned. Oh, the only thing that really will warrant a sanctioning, or for sure where a lawyer is probably going to get in trouble, if it's found out that they're misappropriating funds from clients. That's really the biggest thing. But other than that, all this other crap, Len Kaczynski was never sanctioned. Kratz was never sanctioned. So it's highly unlikely they're ever going to punish Kathleen. If anything, she'll get the court will put in their filing or in their response, like, okay, knock it off. That's essentially what would happen if they got tired of something she did. The state's very tired of it, but that's their own fault. So I'm not going to feel sorry for them. How long does she have to file her reply? It actually doesn't say. It doesn't specifically say because it's an unusual circumstance. But again, the court can rule at any time. They don't have to wait for her to reply. So she will reply quickly. Just like that's why I said the state would reply quickly. And I guess that's pretty good because I said in the last one, I said it wouldn't surprise me if they filed by Friday, and they filed on Friday, just because the court can rule at any time. They don't have to wait the 11 days. They don't have to do anything. And if you notice, there's no due date this time. When she filed the motion, the due date was 11 days from when she filed. And that meant because the state had 11 days to respond. But the court did not have to wait 11 days to give an answer. So there's no due date now. So I don't think there is actually a set time that she has to respond. I think it's just that if she wants it to be heard before the court rules, she needs to do it quickly. Okay, so Julie's saying her theories don't matter, do they? She's showing they held evidence that could have given trial counsel the ability to bring this up then. Well, in some cases, yes. But there are some times where her theories are all built around what she's saying allegedly happened and why this person is a suspect. And so anything that conflicts with that is now going to look like you're just making stuff up as you're going along. It does look like that. I'm not going to lie. I mean, it does look like she has changed her theories based on evidence that's come in. But again, it's just what I said. It's based on newly discovered information. So that's why it's something the court is definitely going to take notice of, and it confuses things, but that doesn't mean she's in the wrong. Because every time she gets new information, it's going to change her theory. She wasn't there, neither were we. None of us know what happened. That's all she can do is give her best guess based on the evidence that she's seen. So she really shouldn't be a huge thing, but it's problematic. It's not ideal. Let's put it that way. It's not ideal. Ideally, you want to select a brief where it's all very cohesive. It all makes sense. It's all interconnected. And we got a lot of pieces floating out all over the place on this one, just because of the nature of how she's had to do it. What happens if KZ tries to get, here, let me change this. What happens if KZ tries to get phone records and they're not available? She's out of luck. Unless she can prove that they were intentionally destroyed. And also retention records only require the state to keep things for a certain amount of time when it comes to electronic records. I think it's something like 7 years. And very. Do you really need me to answer that one? If the remand is granted, odds that Angie will dismiss without a hearing, 100%. I would like to say that I think this judge could read this without any impartiality or with impartiality, not without it, and be fair and no bias. But we've seen enough from her to know that she has actually made things up just so she could deny Steve's claims. So I have no faith in it. I don't know if Kathleen thinks she has a chance. My bet would be that Kathleen isn't expecting much from this judge. Because I remember her saying once that this judge was never going to rule in their favor or something along those lines. So my guess is that she's thinking they're never going to rule in her favor, but she just wants to make sure it gets part of this appeal so that if Judge S's ruling is overturned, that this is included in the appeal. I think everything she's done with these remands is all because she wants to get it all in under one appeal. She'll dismiss. Sue, that's right. Yeah. Hold on now. I can't say this is from because again, unless you connect your Facebook to StreamYard, it doesn't tell me who you are. So I don't know who this is. Tell me your name so I know who you are. The state's diva fit about KZ not contacting them to see if they have contact info for Swinski in their file is hilarious. They've claimed numerous times she has the complete file. Yeah, and we know that she doesn't. Just about everything the state does is hilarious. Not in a good way, but I mean, but what else are you going to do? Because they're ridiculous. I'm just catching up. Is it looking good for Steve? Somebody asked me today if this was bad news, and I was like, well, no, it's nothing. This is literally nothing because the court doesn't rule based on what the state's feelings are. So this was just them whining and complaining and trying to make an argument. But really, I think everything is going to hinge on it's Tina. Okay. Everything is going to hinge on where they are in the case and if it's possible to remand a case when you're already past the briefing stage. I really think that is the key part of this. Well, and the corroboration issue. Because the state's not wrong in that part, that she essentially just filed a motion with some guy's affidavit without anything added to it. The StreamYard gave you a blank screen when you followed the link. Sorry, I don't know how that works. I've never had to do that. But it's Tina. Hi, Tina. Has anyone followed KZ's other cases? These requests of the court, are they common for her? Well, it's common with the respect that she will try to present all the evidence, but this is a very different case. She has never had such a high profile case while she's been working it. Not like this. I mean, she's had some high profile cases, but not like this. Usually she has everything she needs prior to filing an appeal. It's not a case with an ongoing investigation that people are giving tips at all different times. And, that they said this is a very unique situation. This never happens. The investigation has usually been done for years before a prisoner gets to a post-conviction stage, and they're arguing on constitutional errors. They're arguing things that actually happened during the trial, not including an investigation. That just doesn't happen. So it's just really a whole different thing than anything she's done before. If KZ provides evidence of a phone record, what's the next steps? Well, that would be included in her brief that she would present. First, they'd have to grant the remand, and then she would file a brief. The Court of Appeals, just like last time, would set a timeline. They would say that Kathleen needs to file a brief by this date, and then the judge needs to rule by this date. Last time they didn't include when the state had to that the state could respond, and that was a big thing, but they always have a right to respond. Evidence keeps turning up. Let's see, evidence keeps turning up, so she's filing about them timely to prevent procedural bar. Yeah, that's exactly it. And that's just something that does not happen. You will very rarely ever find a case that is constantly getting new information over a series of years, over 5 years, that new information is coming in. Usually there will be one thing that, whether it be a witness coming forward, whether it be DNA testing, there will be one thing that she is pretty much centering her whole post-conviction motion around. And most of the time it's DNA. It's very straightforward. And I think she expected this to have DNA, but it didn't, for the testing she was allowed to do. And so she has to use everything that comes in, everything that is a possible lead. But she does have to have more than just some guy showing up and saying, hey, this is what I saw that night. That's not enough. I mean, and it's understandable why it's not enough, because there's a lot of crazy people in the world. There's people that want to insinuate themselves in the middle of cases. It's just like those guys that commit crimes and then they hang around at the crime scene because they want to see what happens. It's the same type of thing. Like, people just like to do things. So you can't just take a guy for his word when he shows up one day and it's like, oh, I'm a witness, I saw this. Rachel, where's your question? I'm sorry. Okay. is Stephen the only man in the world to be framed twice that we know of? To be wrongfully convicted twice. I know about framed because, people could be framed lots of times, but not convicted. But Steve is the only person that we believe has been wrongfully convicted twice. Obviously, officially, that remains to be determined. But in our eyes, yes, he's been wrongfully convicted twice. This is why I already said this one, right? Yeah. So what's the next steps? So she would provide a brief, and then the state will respond, and then the judge will have a certain amount of time to respond. If she denies their claim, which is what we'd probably expect, then it just gets added to the appeal. We have to go through all this procedural stuff, though, like we did last time. They need time for the record to be sent back down to the circuit court. They need to have the briefs. The judge has a certain amount of time to respond. And then once she files her decision, then we have to wait for the record to get filed back with the Court of Appeals. And I said this last time, but I don't know what that does for where the appeal is right now. I don't know if that means that they have to go back a step and get back in the queue, back in the line for where it would normally be for a case that was just submitted. I hope not, but I don't really know. Again, procedure is kind of out the window on this one. Even the judges are probably wondering, we don't know what the heck to do with this because it doesn't happen. Okay, so Unreal, that's what I meant. Okay. Are there any other questions? As I don't know if there's really much more I have to cover in here. I think I covered everything, didn't I? I mean, they pulled out some from rules of procedure. They're arguing that remanding this case for Avery to pursue another new constitutional claim at this late juncture would be inefficient and unduly prolong this appeal. It says Avery does not seek remand for fact finding on a specific issue raised in his earlier motions. And that's not exactly correct. That's what I was saying before, that it is a new constitutional claim, but that doesn't mean it's not an issue, that the issue isn't related to something that has been previously filed in this appeal. And they're ignoring that. It actually does have a lot to do with what has been previously filed in this appeal. It does say this case is now in a distinctly different procedural posture. Yes, it is. There's nothing that I can argue about that. She can't respond to the state. No. Here, you're saying she can't respond to the state with new evidence. Procedurally, no. When you file a motion, okay, the state can only rebut what you said in your motion. So when they file their response, KZ can only reply to what they said in their motion. She can't add new details. But again, that doesn't mean it's going to stop her from trying. And, the court, I don't know, the court could always ask for more information. I'm not really sure. Like I said, I have no idea what they're going to, nobody should have any idea what they're going to do with this. Because again, this is just, it doesn't happen. It's so bizarre. She has to file a supplemental motion. Once it gets remanded back to the circuit court, then yes, it would be a supplemental motion added to the previously filed 97406 post-conviction motion. No, she filed it on the 12th. In the motion, the very first thing she says is that on April 11th, I was approached by a new witness, Thomas Swinsky, but the actual affidavit that Thomas Swinsky wrote and signed is dated on April 10th. So that's where they're getting that from. So he signed something on the 10th, but she was saying he didn't approach her till the 11th. So clearly that's not correct. And then she filed on the 12th. So that she can address. She can address and say it was a typo, a mistype. She can say whatever, that she can clear that up in a reply. That's why I'm not too worried about that. Oh, Sue, did I miss this? When is MAM 3? As far as we know, there is no MAM 3. There has nothing been suggested about there being a MAM 3. They're not filming. They're not doing anything like that yet. Probably waiting for a break in the case. See what happens with the appeal before they do another one. Sorry, I meant how long will this delay the stuff with the Court of Appeals already? Well, it can be anywhere from 3 months to another year. Just depends how they decide to handle it. That's what I'm not sure about. I think it was 3 months or so the last time they remanded. It was a 3 or 4 month delay, I believe. Because of having to, take that time to send the record back and forth. I mean, they act like they're physically like walking it all this entire file. I mean, it's an electronic file that's being sent. So I really don't understand why you need 10 days for sending the record to be complete. I don't quite understand how that works. But this new information will have to be put on the record and it have to be included, and then the record is sent back to the Court of Appeals. Again, it's electronic document, so I don't know. Oh, you're welcome. He's saying, so glad that I'm explaining it. And I still feel like I stumble around too much and I have trouble with my words, so I'm glad you understand me. Yeah, it's just the Jen is saying, I think it will be granted for remand. Flowers will deny and will be back in the Court of Appeals. I agree with the second part of that. I'm not even sure they're going to grant the remand, honestly. Again, I could completely see them not granting it, but I do think there has to be something recognizing that she can file a successive petition with this claim if they do not allow her to do it now. There has to be something, because they can't deny when she's trying to file something in a timely manner and then say you can't file it now and then later say you waited too long to file it. They can't do that. So that's why I just have no idea how they're going to handle it. And usually the best case would be it needs to be fully evaluated by the circuit court just so we have everything together, and let's just take care of that. But it's just in a weird place right now. How long would it take? Okay, hold on. I'm jumping ahead. So saying theoretically, though, even if it's a typo, she have to have it court corroborated at lightning fast, like less than a day. Well, again, that's if she says he came forward. She came forward on the 10th and signed an affidavit the same day, and I don't know. Because eventually, if she did corroborate this, she's going to have the dates of when she got that corroboration, and that's going to have to match in that timeline too. So just because she corrects it might not mean that she's going to correct it only to a day earlier. She could correct it. Oh, I meant a week earlier. We looked at the wrong day in the calendar and we meant he approached us a week before that. And what are they going to say? She's lying. Unfortunately, kaboom. That's not what she said though in her motion. That's the problem. I don't know when she was approached. How long would it take to access the phone records if they're suppressed? No. If something was suppressed, they hide it, then there's nothing she can do about it. And again, retention records state that I believe it's only 7 years, 7 to 10 years usually, that the state has to keep any electronic records. So that it's actually within the law that they could destroy anything from that time, and they would be within the law to do that. So there's a lot of reasons why she might not be able to find those records, and how long it would take, I don't know. It depends on whether it's there and they have it accessible, or if they don't have it and it's gone, if they have to search for it. Hi, Eric. Good to see you. I'm probably going to be wrapping up soon because I don't think there's too many questions. There's really not a lot to unpack here. It's go back. Yeah, so you could just go back and watch my video from 2 years ago because it's essentially the same argument. The state wins no points for originality, that's for sure. But if that's it, then I'm going to wrap it up because I will be doing another one when Kathleen files a reply, and probably within a day or two. So You'll be seeing me again soon. And then I'm going to be doing part of the live stream that's going on this weekend with the Keep Walking Till They're Talking. I am going to be live on Sunday at 1 p.m. Central Time. That's going to be my 1 hour time slot. And I will probably just talk more about what has all happened this week. To at least have something to talk about for an hour. Okay, Eric wants to know, how much am I putting into this new evidence? Well, right now I can't put really much into it because we don't know anything other than just what this guy says. I need to know what the corroboration is. I need to know what else we have to substantiate that this actually happened. We do know they weren't pushing the car uphill. That we know. The state hasn't even got that part right yet. But no, I can't say whether I think this is legit or not because I literally have no information other than this guy's word, and that's not enough. Is this enough for a Denny claim if we get a hearing? It helps because, again, as I said before, one of the prongs of a Denny claim is that you have to show that the suspect has a direct connection to the crime. Obviously, if Bobby is pushing her car in the middle of the night or early morning hours, that gives him a direct connection to the crime. A direct connection to her car is a direct connection to the crime. Do they know who he spoke to? He said it was a female deputy, I believe, but they really don't know that. I mean, again, he could have gotten a dispatcher, he could have gotten a call center, he could have gotten anyone. So as far as I know, they had not identified her as of yet. And they have not identified the other man that was with him as of yet. But Kathleen said after she filed that motion, she said she was getting a lot of tips as to the identity of that man. So that proves right there that there's more investigation going on that we're aware of. Because obviously she's following up on these tips. We don't know how legitimate any of them are, how good, how bad, how ridiculous. So yeah, so there's a lot that we just don't know. You guys are welcome. Everyone's saying thanks. And people are already heading out. So I don't want to be too long. So that's it for now. And I will see you probably within a couple days. I said that Kathleen will file this real quickly. Oh, Julie, that's a good point. Yeah, we did talk about this. I forgot we talked about this. If this witness shows his phone bill, is that sufficient corroboration? Yes, it is. It would obviously be better to have a recorded conversation of him saying specifically what he's stating in this affidavit. That's an ideal situation. But if she can get a hold of his phone records, just like they went back and got a hold of Teresa's phone records, then that would at least be, I'd say, sufficient corroboration to prove he made that phone call. Can't prove what it said, but it proves he made the phone call. So why else would he be calling on that day on November 5th if he didn't have a tip or some information to give them? So yeah, that would be a start. If she can corroborate the phone call, if she can corroborate his phone records, if she can corroborate that he had contact with Buting and Strang, or that he left a message for them, or there's a notation, even if they overlooked it, if there's something in their case file that got missing and then is later found once they knew what to look for, that would be corroboration. It would be corroboration just to find out for sure that's who he worked for and that was his paper route and that he did deliver at that time of the morning. That would be some corroboration. Any of those things would at least be helpful. Obviously, ideally, we hope we have that lost flyover video that shows that, somebody moved it there. But, we don't know. Spring Stew audio interview may help. Okay, which one is that, Millbilly? Because I don't know which one that is. I know who Ricky Springstube is. I've met him personally when he chased me up the deer, whatever it's called now, the deer camp property. Oh, he does bring that up. Okay, I haven't listened to that. Okay, that's interesting. But what does he say specifically? Do you want to come on and explain it? I can give you the link because I don't know what that is. Yes, and if the gray bearded person comes forward, that would be witness corroboration as well. Yes, you have another person that would say, "Yeah, I was out there pushing a car." That's certainly really big corroboration. Well, here, I'll post the link. Hopefully nobody else, if you want to come in. If you don't, that's fine too. I haven't seen this, so hopefully I'll get no surprise guests like the last time I shared a StreamYard link. But yeah, if you feel like when coming on and explaining what that says in that DCI report or what exactly he said, because I have no idea. But I definitely know who Ricky Springstube is. He got a little angry. We calmed him down though. He was good after he figured out we weren't there to hurt anything. Anything else you guys got while I'm waiting? Stop it, Sue. Yeah, so there are a lot of different ways that this could be corroborated. It's just a matter of what she can get her hands on, what's still available. That's always the case with this whole thing is that too much time has passed, or not too much, but so much time has passed that's really hard to go back and find what you're looking for. Oh, there's Billy right now. Hey, dude.
Let me get my headphones.
All right.
Can you hear me?
Yep, you're good.
All right, I'll get the DCI report. Hold on.
While you're looking for it, Jen just asked, while we wait, heard from Ricky Kidd. I've wondered how his efforts are going. I don't know if you saw when I was on with Paul, Ricky actually had a massive cardiac event. And he had to have, was it triple or quadruple bypass surgery? But he had to have heart surgery. And he is still recovering, but he's doing really, really well. He's doing really well. He's recovering nicely, but it was pretty scary. Luckily he went to the hospital when he knew something wasn't right because it ended up being pretty serious. But he's hanging in there, but he's still got some recovery time ahead of him yet.
All right, I got it.
So what is he saying exactly that you think could help?
The problem is it's a rendition of what we don't hear the questions that were asked to him. He just let's see right. You see that?
Yeah.
All right. Spring Tube stated that the normal mail delivery time in the neighborhood is somewhere between 11 a.m. and 2 p.m. He stated that the local newspaper, the Herald Times, is normally delivered on a daily basis. Why are they asking him about this, for one? This is the day after this guy supposedly called in.
Okay, so the normal in the neighborhood is somewhere between, what times does he say? Between when and 2 p.m.?
Yeah, the mail. And then they add that he stated that the local newspaper the Herald Times, is normally delivered on a daily basis, approximately 9:30 a.m. Is that when he gets the paper? But like I said, we don't have the questions that were asked to him. So
yeah, that makes it sound like it's not delivered till 9:30 a.m. and he lived right there. So
yeah, right at the end of the road.
So that's a little late in time, but
why is he even talking about the Herald Times in the first place?
Right. Yeah. That is interesting. No, I hadn't seen that. When did that come out? Is that from a while back?
Yeah. Well, the date of the interview was on the 6th. It lasted from 11 a.m. to 11:20, and approved on the 16th of November 2005.
How long have we had that document though? Has that been released?
I believe it was in the ones that Joras and Ricky Foyed.
Okay. Yeah, that's interesting. Like you said, that he would even bring that up. Like, why don't they include the questions? It's like he's just randomly stating all this stuff for no reason.
Mm-hmm.
That seems odd.
Very odd.
But he lived in there. Where the sign is, wasn't it? Because where the sign is now, that's where a house used to be.
Mm-hmm.
Right. Yeah. Yep. So that's where
on the southwest corner of Avery Road. just
Yeah.
about
So
probably about 100 yards to get that.
literally the same street of where they were seen pushing the car.
That's right.
Yeah. So, and I don't know if many people know that, but that there used to be a house there where the sign is now. All right. Well, thanks for explaining that because yeah, I hadn't seen it, so I wasn't sure. And yeah, that definitely is another interesting thing to point out.
We sent it to KZ. Maybe she actually has the interview with him. Hopefully, may shed some light.
Spring Stew is not really loving this whole thing right now, but hopefully he'll cooperate. He doesn't like it when people go on his property, but you know. I didn't know you couldn't turn around. I did not know that if you go down, you turn by the deer camp. I had no idea that there was nowhere to go except for you have to go around where all the trailers are. So you have to go to circle and you're just like, hi, everyone. You have to get back out again. There's nowhere else for you to go. I thought we could just drive past the area. I didn't know that you actually have to trespass once you go down that road. So, oops. So, yeah, but that's interesting. Well, thanks for coming on. I appreciate it.
No problem.
All right. You out?
Yeah, I got some things to do.
All right. See you later.
Later.
Okay. Well, that's good. That answered that question then. It is very interesting. Yeah, it just makes me think she has a corroboration. I think she absolutely has something. Because again, I know I've said it many times, but I just don't see her doing this. This is a drastic step to take on just someone saying, "Oh, hey, I saw something." But maybe, even if she can corroborate when that happened. Now, see, if the state had seen that, if the state had that DCI report, which they do, but if they were aware of that, I could see them putting that in their argument. Because that would be a good argument against it, saying that the person who lived right there on the same street said that it was delivered at 9:30 a.m., not 5:30 or 6 o'clock, which is what it would have to be for the affidavit to be correct. So, not that we want to give them any ideas, but I don't think they're watching my videos. Yeah. So that's very interesting. It's an interesting piece there. I didn't think about the fact that I forgot about someone actually lived there right down the street where that happened. So, all right. Any other questions? Last call. Hi, Chris. Glad you made it at least for a little bit at the end. And again, I'll be back on when she files a reply, which will probably be tomorrow or Wednesday. And then we will wait for the court's decision. I can't remember how long it was. Let me look. It was almost a month after the state filed their response last time. The state filed the response January 29th, 2019. And then KZ filed a reply a few days later. And then the Court of Appeals decided it on February 25th, 2019. So close to a month for them to make that decision. So once we get the reply, then we'll have a little bit of a waiting time again. And then hopefully we'll have something good to talk about and it's being remanded. But either way, the appeals moving, we're going to keep moving forward one way or the other. Sabo was saying, also correct me if I'm wrong, but it was somewhat dark. Could the identity possibly be a younger person, but may have looked older? Yes, I agree. I agree with that. I've already said that a couple times, especially when somebody has a gray beard. I know, like, for example, my stepdad, like he had his hair didn't turn gray, but his beard turned gray years before his hair turned gray. And it did make him look older. So my mom used to always tell him to shave because he looked so much older with his gray beard. So I definitely think having a gray beard, and in particular having a longer graying beard, I think can absolutely make somebody look older. And especially if you're not getting a good look at him. He said that Bobby was in front of his vehicle, in front of his lights, so he could get a good look at him. The other guy, it doesn't sound like he got a very good look at him. No, when I say, like I said earlier, I'm probably referring to the last live, not earlier today. I don't remember. I don't remember what I said or when I said it. Ask Julie. I made a comment in our chat today that I had literally just said 5 minutes earlier. I said I can never remember if it's something that I just thought or if I actually put it down on paper or chatted it. And turns out I did and I didn't realize it. So yeah. My memory's not so good. All right, I'm wrapping it up for real. We're at an hour mark. That's perfect. So thanks everybody for tuning in, and I will talk to you soon. Bye.